Hello everyone. Today we have with us Mr. Divyam Agarwal, partner at Jyoti Sagar Associates. Thank you so much for joining us today, sir.
Thank you.
So today we are here at International Conference on Arbitration. So there are a lot of talks going on about the arbitration and conciliation, recent changes that are being brought about via the 24 Amendment Bill. So, sir, what is your say upon that? There's a lot of interference of courts that has sometimes hampered the enforcement of an arbitration award. So, are there any good changes that have been proposed by this bill which will reduce the interference of courts?
See, as if you look at the scheme of our arbitration, first of all, thank you for having me right now. If you look at the scheme of our arbitration, Section 5 itself talks about minimum judicial intervention. And we have sometimes utilized certain provisions in the Arbitration Act to our advantage in getting a protective measure from the court. However, there have been instances where courts have also gone overboard with their intervention in the entire mechanism. I would say that now that there is a complete shift in the mindset of the judiciary, completely shift in the mindset of the advocates as well, that we have to keep the two separate and only have an intertwined functioning between the two as an exceptional measure, as in when required. I definitely welcome a lot of changes which have been proposed. One change which we just discussed before our discussion right now was on the emergency arbitrator that across the globe that is considered to be a very effective way of getting a relief at an immediate situation because it can't wait for the entire process to follow. While Section 9 historically has been like a sort of an emergency arbitrator, but providing a specific emergency arbitrator provision can be giving it an interesting spin. What one definitely must be wary of is that that provision should not be misused so as to again give more impetus and more arm to the court to intervene in the arbitral procedure.
So, arbitration has always been seen like an effective, more effective, and a faster procedure as compared to courts. However, these provisions where people approach the court for interim award and when they challenge it, earlier there was also an automatic stay on the award. So, how do you think we can overcome this so that it actually becomes a faster mechanism?
Which is, it's a very fair point, and that exactly dissuades a lot of people to go for litigation, and because they believe that arbitration is the more speedier remedy. What we were discussing inside during the conference was the harmonization of these three mechanisms: arbitration, litigation, and mediation. It's very important. What we need, see, there is no one size fit all approach. There is no formula. It has to be seen from a case to case basis. What you also need to see is when do you require mediation, when do you require to actually approach court. That approaching to the court in a given scenario in an arbitration must be very limited, and only courts will entertain on a very immediate, urgent basis. Then you'll go for a pre-mediation litigation. Again, that has its strengths, with very important procedure, which, if followed properly, can really reduce your dispute life cycle to a bare minimum. So you need to draw that harmonization between these three processes. Every process has its own advantage and disadvantage. You just need to pick them up, weave them in such a manner that, and as I said, calibrate it in such a fashion that every appropriate stage you are before the right forum, and any abuse of any of these procedure, where be it arbitration, be it mediation, be it litigation, it's likely to cause a problem at a given point of time.
So, Justice Nagaratna raised a very important point during this panel discussion that people approach courts more because maybe they trust courts more as compared to the alternative mechanisms. So, what is your opinion on this, and what would you suggest that how can we build that trust so that burden can be lessened from the courts and ADR can actually become a very effective or equally effective mode of dispute resolution?
I think the way to bridge this gap is actually to have the right institutions like ICA. They really need to step up. They really need to up their game, ensure that, and which they are. I must commend ICA. They are doing that, and various other institutions are also doing. What is to be seen is that these institution needs to come forth, provide that trust, that confidence, that I would say a pedigree, where they are every lawyer, arbitrator, judge screened. They are you need to see whether they have any past antecedents. We need to see whether they have the right knowledge of the subject, whether they have a technical expertise. All those factors needs to be combined together, and you have to then repose the faith in that arbitral tribunal which you have put forth. That is why, if you look at it historically, judges as the arbitrators have thrived, because there is an inherent trust which we all repose in a judicial system, which percolates down to a retired judge who becomes an arbitrator. But not in every situation you can have an arbitrator who is a retired judge. There are fairly technical issues which are getting thrashed out in an arbitration, and you require experts. But whether that expert is to be trusted, whether that expert is really going to be impartial to the parties, that kind of a screening has to happen at the level of an institution like an ICA or the various other institutions we are aware of.
Right. Thank you so much,
Thank
sir,
you so
for
much
being
for
on
having
our
me.
channel. It was a very enriching discussion.
It's my pleasure.
Thank you, sir.
Thank you.